देखो एक पॉइंट में अगर मैं आपका डिबेट खत्म करूं, मतलब कि बाद में मैं आपके डिबेट पर आऊंगा, तो ये है कि देखो उनका कोई अपना एजेंडा नहीं है, लेकिन इलेक्शन में उस इशू को कैसे उठाया गया है आपको पता ही है। ये पिटीशन एक फाइल किया गया है सुप्रीम कोर्ट में, चैलेंजिंग द 3 टर्म्स एडेड इन प्रीएम्बल. So we started amendability debate and basic structure doctrine, and it is one of the most technical parts of polity. This, and as we told that yesterday, if you understand fundamental rights, you understand polity. This, so let's take that how the debate is started. So yesterday we told that it starts with Article 13. This. So Article 13, if you read, so it has clauses. Clauses 1, 2, this 3. We told yesterday that one is about past laws, and this is about laws, means laws after, so 26 January blah blah 1950, and 3 is about definition of the defines law. What is law? This. Then the debate origin, let's say that the government after independence, it carried out First Amendment Act. It carried out First Amendment Act, and that First Amendment Act added, it is Article 31B, sorry, 31A and 31B. Then it added Schedule 9. Originally our constitution had 8 schedules, but then let's say the 9th schedule was added by First Amendment Act. This. So what were, let's say that these amendments, what they try to do? Basically in generic sense, if you say, so they are about agrarian reforms. You know that agrarian reforms that we wanted to carry out, including land distribution, land acquisition, these things were important for development of the country. This. So 31, let's say that this Article 31A was related to acquisition of some estate. That's it. State means property. The state can acquire any such property. State can take over management of any such property, etc. A set of 5, I think, parts you'll find that in this 31A. Basically, it is, you can say that it is related to land acquisition, acquisition of any property, and when state acquires any such property, so it will have, let's say that reasonably free hand. This, that way it is. So it is related to this, and let's say that 31B was related to, let's say that any law kept under Schedule 9 will not be subject to judicial review. This. So it will not be subject to judicial review. Here let me add that it was mentioned that all these, let's say that the components, if government make any such, let's say law, etc., so article 13 would not apply. Basically it was written like this. In case of 31A, if government brings any legislation, takes any steps, so article 13 will not apply to those. Means even if the steps taken by the government, they contravene this. So when they contravene, they cannot be declared as void. So 31A was given protection of article 13 and 31B, that's this. 31B gave protection to those laws which were kept under Schedule 9. This, try to understand. Basically, government will try to, there were two things government did by this act. First, it wanted to save the laws from application of Article 13. And second, it wanted that there should not be judicial review on those laws. Right. So 31A was giving protection of Article 13. It will not apply. And 31B was that judiciary will not have judicial review on those laws. Means they will not be subject to challenge in judiciary. This. And that is how 31B is giving protection to those laws kept under Schedule 9, and 31A is giving protection to Article 13. This. It means the amendment first was considered in a way obstructing fundamental rights, affecting fundamental rights. This, it is affecting fundamental rights. Right. And it was also amendment in fundamental right. Schedule 9 was not amendment in fundamental rights, but 31A, 31B you have added, it is amendment in fundamental right. This. So the first question was that can Parliament amend fundamental rights? This. Can Parliament amend? So whether fundamental rights were amendable, that was the debate, because Parliament was given amending power under Article 368. So it was that whether fundamental rights could be amended. This is first. Second, if they could be amended and they are contravening with Article 13, then what will happen? Can they be declared null and void? This. So that will happen only when, let's say, the challenge was done. The challenge was, this amendment was challenged on the ground that whether the law that you have, this term law, whether this law has also included a law made through amendment of Constitution. This, if the term law is included in 13, this by amendment, see, when you amend anything, so it also becomes a law, a separate law you can consider. So 31A becomes also a separate law. This 31B becomes a separate law. This. So whether the term law in 13 also includes, right, any law which is made through amendment, right? And if it includes law through amendment, then it is contravening this part. So when it is contravening this part, it will be declared null and void. Right. Simply if the law in Article 13 also includes a law made by amendment, it means then fundamental rights cannot be amended, as those amendments may contravene this part. This. That is how the challenge known as Sankri Prasad case. Right. The first challenge was Sankri Prasad case. And that is what, let's say that debate starts, the evolution you can say that. So, or basic structure. Basic Structure Doctrine. So it starts with First Amendment Act, which added Table A and B, Schedule 9. Challenge is Shankari Prasad. This. Now, in this debate, this is how. So let's write the background, summarize it, then we'll start with this. Right. After, let's say that, after the enactment of the Constitution, the First Amendment was carried out. The First Amendment was carried out in 1951 to bring agrarian reforms for promotion of planning, socio-economic development, and welfare of people. Right. That is, the government tried to implement DPSP, which demanded flexibility in implementation. That is, fundamental rights should not come on the way of securing social justice for society. The First Amendment Act gave protection. To the laws and policies which were needed relating to land acquisition, land reforms, acquisition of properties. Hence, Article 31A was added. Which gave protection of Article 13, that if government acquires any estate, Article 13 would not apply. To those laws. Next, 31B was added. So that land reforms related laws land reforms related laws should not be reviewed by judiciary. Hence, Schedule 9 was created. Schedule 9 was created to keep those laws in this schedule, and keep judicial review outside the purview of Schedule 9. Schedule 9. This amendment was challenged. Popularly known as Shankari Prasad case. On the grounds that first, whether fundamental rights could be amended. Second, whether the term law in Article 13 also included a law made through amendment of Constitution. Change paragraph. The view by judiciary. Which view? The view of judiciary, let's say, the view of judiciary kept changing on the above matters, which gave rise to further amendments and cases, which ultimately resulted into emergence of Basic Structure Doctrine. Structure doctrine. Like in brief, it can be stated that first, in Shankari Prasad case, the court justified amendment. Next, the government carried out further amendments like 4th, 17th, which were challenged. 17th, which were challenged. Next, Golaknath case. Next point, Golaknath case. In this case, the Supreme Court took a different view from Shankari Prasad, which resulted into 24th and 25th Amendment. Amendments. Next, Kesavananda Bharati Case. Kesavananda Bharati Case. Right. Both amendments were challenged. In this case, Supreme Court propounded Basic Structure Doctrine. Basic Structure Doctrine. Propounded Basic Structure Doctrine. Next, the government carried out 42nd Amendment Act. 42nd Amendment Act to reject Supreme Court judgment. Supreme Court judgment. Next, Minerva Mills case. Minerva Mills case. The Supreme Court struck 42nd Amendment Act in bracket objectionable parts. Objectionable parts. Finally, this case settled. Debate on amendability and basic structure. Basic structure. So thereafter it is known as post Kesavananda Bharati era. Post Kesavananda Bharati era, in which basic structure doctrine post Kesavananda Bharati era, in which basic structure doctrine has been time to time re-strengthened. Has been time to time era. Kesavananda Bharati era, in which basic structure doctrine has been time to time re-strengthened through right. Just we gave you a brief, then we'll explain it. What happens, let's say that, what we have told, we'll tell in detail no doubt, but what we have tried to tell that, when First Amendment was challenged, so basically that time judiciary took a liberal view. Right? Then the government carried out, there was no any, let's say, obstruction in the actions of the government. Government further carried out reforms, this and that. Several amendments were carried out. You can say Fourth Amendment, Fifth Amendment, Seventh Amendment, 17th Amendment. So many amendments were carried out to reform. And further 31A, 31B, their scope was broadened, basically. They did not add new article, but just they broadened the scope of 31A, 31B, and Schedule 9. This. Finally, let's say that when 17th Amendment was carried out, which added in 31B, so that was challenged again, which we say as Golaknath case. Now, this time Supreme Court took a different view. Yes, different from Shankari Prasad case, and simply told her that you cannot amend constitution. This, so then it was a very radical view. So legislature reacted in that way. Right. ठीक है, बोल के दिखाओ कि नहीं अमेंड होगा, हम तो अमेंड करके रहेंगे. तो लेजिस्लेचर ने 24th 25th अमेंडमेंट लाया. इसलिए अभी आपने जो आज के डेट में देखा है एग्जीक्यूटिव और जुडिशरी के बीच, ये तो कोई कुछ नहीं है. वो टाइम था 67 to 73. The judiciary, we know that, fought against the government. So that was different judiciary. The 24th, 25th was carried out, amendments. That finally, let's say, Kesavananda Bharati case. Here they took, let's say, very comprehensive view, which is also acceptable view, you can say, giving rise to call basic structure doctrine. But government मानी नहीं. Government, you know that कि गवर्नमेंट ने बिल्कुल रिजेक्ट कर दिया जो भी जजमेंट दिया सुप्रीम कोर्ट ने 73 में. दे रिजेक्टेड ऑल. हम नहीं मानते बेसिक स्ट्रक्चर डॉक्ट्रिन को, राइट, और तुम्हारा पावर भी हम ले लेते हैं कि यू कैन नॉट रिव्यू. द जुडिशियल पावर वाज टेकन अवे. दिस that was done. The government took away judicial review power and basic structure doctrine was rejected by 42nd Amendment Act and DPSP को पूरा fundamental rights का overriding बना दिया. This. Then let's say that कि कोर्ट ने मिनर्वा मिल्स केस में रिजेक्ट कर दिया. कोर्ट rejected whatever government took steps in 42nd Amendment Act, especially related to those parts. Because 42nd Amendment Act also included many other things which were not related to this debate, you know that. So Minerva Mills case rejected, struck. Fortunately, thereafter legislature did not react. Legislature ने अगर react किया होता तो बात कुछ और होती. Legislature did not react, and thereafter one after another, some cases will be mentioned in your Lakshmikant, some cases in Didi Basu, this and that source you read. Thereafter what judiciary did is that whenever they gave some important judgments, so there they kept saying that it is basic structure, it is basic structure, it is basic structure. This, so that way you can have a list of basic structure. Like, so basically Indira Sahni case, rule of law, they say basic structure. SR Mumbai say, let's say a list of things, secularism, this and that, they to consider basic structure. IR Kolo case, let's say again, let's say this is they have told about basically social justice, equality related things, the relationship, you can say that. And finally here independence of judiciary, you can say. Independence of judiciary is basic structure, which we will tell you all important cases here and there. यहाँ पे नहीं बताएंगे सारा, but throughout the discourse of our polity, we will tell you those cases. So you will come to know at one place, right? Anyhow, so let's take that how this debate. So it is in a way we say at evolution. That evolution can be divided into this Kesavananda Bharati before and after this. So what, as let's say that, so here what they say, Shankari Prasad say, so they say, let's say right, so let's write in this. The evolution of the debate is as follows. The evolution of the debate is as follows. First, Shankari Prasad case. Shankari Prasad case. The Supreme Court went on validating the amendment. The Supreme Court went on validating the amendments. That first, the term law in Article 13, term law in Article 13 does not include A law made through amendment. A law through amendment. Right? And hence, fundamental rights could be amended. Hence, fundamental rights can be amended. Amended. Next, it did not strike Schedule 9, which was kept outside the purview of judicial review. Outside the purview of judicial review. This next, Golaknath case. Golaknath case. Since government carried out other amendments, like including 17th Amendment, which broadened the scope of Article 31B. It was challenge which came to be known as Golaknath case. Golaknath case. In this case, the Supreme Court took a different stand. That the term law in Article 13 also includes law made through amendment. A law made through amendment. This next, a law made through amendment. Now view changed. In Shankari Prasad they say that it is not law under the meaning of law of Article 13. Here they are saying no, it is a law under the meaning of law of Article 13. Right? And then let's say that part 3 has been given transcendental position. Right. Transcendental position. Transcendental position means, let's say that right, immune or immutable. Right. Transcendental position or immutable. Right. That is, fundamental rights are absolute. Fundamental rights are absolute and they cannot be amended. They cannot be amended. Right. Hence, it was a very radical stand taken by judiciary. The government reacted. Right, by bringing 24th Amendment Act, 25th Amendment Act, this. Now, it added many provisions, but यहाँ पे जो अभी हम mention करेंगे, right? Although we mentioned yesterday while teaching amendment, isn't it? Bill, basically, constitutional amendment bill, veto power, joint sitting, they were also part. But here it, let's say, 24th Amendment Act, it adds Article 13, Clause 4. This, because there were 3 clauses originally mentioned. The Clause 4 was added. And then it adds Article 368, Clause 3. This. What government added? Simply that nothing, right, nothing will apply to Constitutional Amendment Act. Right. Means this law will not apply to Constitutional Amendment. Right. This, here they added that Article 13 will not apply to a law made through Constitutional Amendment Act. This, and here they added, right, Article 13 will not apply. This, in amendment also they added, there also they added, so that they give protection. Basically, 24th Amendment Act was nothing but to nullify Golaknath judgment. What 24th Amendment is doing? It is nullifying Golaknath judgment. Nullifying Golaknath judgment. Right? 24th Amendment Act. Yes, what, feeling cold? Right. We don't know, हम लोग क्लास में पढ़ाते हैं वो पता नहीं कहाँ चले जाते हैं. मौसम ठंडा हो गया है. उस दिन तो काफी गर्मी लग रही थी. दो तीन दिन तो ऐसा लगा कि कहीं भी आग लग सकती है. 2 दिन तो वहाँ करोल बाग के आगे पीछे ही हुआ. 2 दिन. यस, नेक्स्ट डे भी दूसरे होटल में एसी ब्लास्ट हो गया. अच्छा, एसी ब्लास्ट हो गया. बस, तो होटल में एसी ब्लास्ट हो गया तो इट स्टार्टेड, लेट्स से, स्मोक एंड दिस एंड दैट, लेट्स से बस. So anyhow, then the basically 24th Amendment Act is nullifying that. This. Now, what it did is 25th Amendment Act, it further broadened the scope of, let's say, land reform, you can say, or steps related to socio-economic development. So what it did, this says 25th Amendment Act added, let's say, that another article, Article 31C, A, B, C. This you should know that. So 31C was added. This. And what 31C is saying? 31C says that Article 39B and C, right, will have precedence over Article 14 and 19. Right. Now 39B and C are related to, again, let's say reduction in concentration of wealth, redistribution of wealth. देखो कॉन्स्टिट्यूशन भी रीडिस्ट्रीब्यूशन ऑफ वेल्थ की बात करता है, लेकिन इलेक्शन में उस इशू को कैसे उठाया गया है आपको पता ही है. Constitution also talks about redistribution of wealth. This rather DPSP envisages for reduction of concentration of wealth to promote equity and equality. That if government wants to take any steps to redistribute wealth, to concentrate, to reduce concentration of wealth, those policies, if they violate equality principle and freedom of individuals, so they would not become basis to be challenged in the court. Right? This 39B and C become superior to Article 14 and 19. Right? This you should know. So that is how it was done. Now again it will be challenged. So let's write few lines on that. In reaction to Golaknath case, the government added 24th and 25th Amendment Act. 24th Amendment Act tried to nullify. 24th Amendment Act tried to nullify Golaknath judgment by adding Article 13 Clause 4 and Article 368 Clause 3. Article 368 Clause 3. 25th Amendment Act broadened the scope of socio-economic planning and development. By adding Article 31C. Which gave precedence to Article 39B and C over Article 14 and 19. That is, if government takes policy interventions to promote redistribution of wealth, and if they violate Article 14 and 19, citizens cannot challenge them under constitutional remedies. This. Next, Kesavananda Bharati case. Books will not give you all these things. किसी भी एक बुक में आपको ये सब मिलेगा नहीं. So, Kesavananda Bharati case, 1973. The 24th and 25th Amendment Acts were challenged. 24th and 25th Amendment Acts were challenged. challenged, known as Kesavananda Bharati Case. Kesavananda Bharati Case. In this case, the Supreme Court in 7-6 judgment, 7-6, let's 7-6 judgment gave following views. This first, the term law in Article 13, the term law in Article 13 does not include a law made through amendment. And hence fundamental rights can be amended. Fundamental rights can be amended. Yes. Next. It gave a new idea of basic structure. Basic structure. That is, not only fundamental rights, but also any other parts of Constitution can be amended except basic structure. Except basic structure. Next. It validated Article 13, Clause 4, Clause 3. It validated, this is first, then second, Article 31C. It did not strike the amendment which were done, let's say. 31.4, it was validated. This was also validated. And 31C is also validated. Yes. Right? Clear? So it validated that, this you can say. So what it struck? Struck the purview of judicial review. The purview of judicial review, which was kept right, out of Schedule 9. Out of Schedule 9. That is, judiciary can review Schedule 9. Judiciary can review Schedule 9. Can review Schedule 9. Right? Let's say, however, it did not define basic structure. However, it did not define basic structure. It did not define basic structure. Right. Right. Since Parliament was bound by basic structure doctrine, even if it was recognized that fundamental rights could be amended, the government reacted through 42nd Amendment Act. The government reacted through 42nd Amendment Act, right? So you should know that finally we got settled to some of the views. Right. First is that the law does not include, this is a final view, since then it has not been challenged. It has been taken from them that the law under Article 13 does not include a law made through amendment. That is how Kesavananda Bharati's case says. Right. The framers of the Constitution did not intend that the term law here also includes a law made through amendment. That was told in Kesavananda Bharati Case. Right? And this is how, let's say, it is a final view. Since it does not include a law made through amendment, so then that part can be amended. We can add this. So you can add, but then that amendment should not alter the basic structure. The restriction they impose, you can amend. You can amend, but you will be bound by basic structure. What is basic structure will take separately. This. You are bound by basic structure. This. Now they validated also those amendments government carried out. At the same time, one thing they struck was Schedule 9. Since first amendment, you know that Schedule 9 was kept outside the purview of judicial review. Now in Kesavananda Bharati case, they say that no, judiciary has the purview of Schedule 9. And any law kept under Schedule 9, judiciary can review it. This. And that was further reiterated in I.R. Coelho case. This in 2006, which we'll talk later on. So, and this judgment was given on 24 April 1973. You should know that. This judgment was given on 24th April 1973. Therefore, since that judgment day, all the laws which have been kept under Schedule 9 can be reviewed by judiciary. Not the laws which were kept before. Right. All the laws kept under Schedule 9 can be reviewed by judiciary since 24th April 1973. This, right. That is how it was struck. Now, first thing what it broadened the judicial review and it imposed basic structure limitation. Right. So, government did not agree on this. Government thought that amending power was absolute. Parliament was sovereign to amend the supremacy, let's say. The Parliament was sovereign, but what they have done? They have further, let's say, that brought constitutional supremacy. This, but Parliament thought it was sovereign like UK Parliament. It was not bound by anything. The framers of the Constitution did not intend to impose any limitation on amending powers of the Parliament. Hence, Parliament can amend anything. Therefore, government reacted by this and by this by bringing 42nd Amendment Act. And it was not only 42nd Amendment Act, rather it was a review of the Constitution. The biggest amendment ever done in our Constitution was by 42nd Amendment Act. This. So, government how it reacted? 42nd Amendment Act. This. So, first thing it told that what they did is that 4 and 5th they added to give unbound power. Right. Parliament was given unbound power, and then judiciary cannot review. You cannot strike. This. So they brought under Article 368. This. And then बदमाशी इसको बोलते हैं, हालांकि लेट्स की आई हैव बीन ट्राइंग टू बी मोर फॉर्मल. दिस तो गवर्नमेंट ने बदमाशी दिखाया. राइट. उन्होंने डी ऐड किया 31D टू गिव DPSP precedence over fundamental rights. Entire DPSP, right, means part 4 was given preference over part 3. जो करना है कर लो. Right. So it altered the balance between DPSP and fundamental rights. So only 39B and C nahi. It's not only 39B and C, rather entire DPSP will have precedence over fundamental rights. This. Plus it added so many other things by 42nd Amendment Act, which are not part of, let's say, this challenge. You know that in preamble also 3 terms were added that you can consider. Similarly, let's say that fundamental duties were created, so they were added. Let's say this. So we, let's say, it went on adding so many provisions. Preamble is not part, let's say, basic structure. Preamble values are. Right. Preamble as such, उन्होंने ऐसा कभी बोला नहीं है. बोला है? नहीं बोला है. Preamble as such, let's say, it is essential part, let's say that. They say it is essential part. अब जब आप रिमूव करोगे तब वो डिफाइन करेंगे कि नहीं ये बेसिक स्ट्रक्चर है, आप नहीं रिमूव कर सकते. बट ऐसे उन्होंने प्रियम्बल को ये नहीं बोला है कि बेसिक स्ट्रक्चर है. किसी पार्ट को उन्होंने नहीं बोला है कि ये बेसिक स्ट्रक्चर है. Rather they have defined the values, let's say that, principles, let's say that, them as basic structure.
Okay, so when explicitly adding
yes.
terms, socialist, secular, values. So since it is adding to the values, so it's not a like they did not.
Yes, if you enhance the values, so it is good. If you dilute the values, then it is not good. This, so that way we can say. Now it has been challenged although. आपको पता है कि ये चैलेंज हुआ है, कोर्ट ने एक्सेप्ट भी कर लिया है. ये पिटिशन एक फाइल किया गया है सुप्रीम कोर्ट में, चैलेंजिंग द 3 terms added in preamble. Since they were not part of the original constitution, so can they be added in the preamble? तो सुप्रीम कोर्ट ने एक्सेप्ट कर लिया है. Whether they will give a judgment or not, that's different thing. Right. But those things were not part of challenge in Minerva Mills case. This you should know that. This. So this is how you will find that it was added. Now you know that it is 42nd Amendment Act it is considered. Like say that it is an example of also dance of democracy. Right. डांस ऑफ डेमोक्रेसी लेट से उसका हिंदी ट्रांसलेशन बहुत बुरा है, मैं नहीं करूँगा. एंड दैट इज हाउ यू शुड नो दैट. That is also manifestation that when an executive is in majority, so how it can threaten constitution. Right. A majority government, suppose it enjoys majority like anything, so you know how constitution can be distorted and constitution can face its threat. This, that is what you should know. And it is difficult to stop if there is a majority government from distortion of constitution. This, the way it was done by 42nd Amendment Act. And that is how it results into the challenge. Such changes were challenged in Minerva Mills case. Right? The next case comes, this is how. This. In this case, let's say that case. Right. Supreme Court struck this. It struck that Right. So Kesavananda Bharati case, this is how it happened. Sorry, we say Minerva Mills case. In Minerva Mills case, it stopped those things. And then it reiterated that there is basic structure doctrine, means it accepted the basic structure doctrine. It says Parliament had limited power, which we have already told yesterday in that manding. This and Kesavananda Bharati judgment restored, basically you can say that. Whatever Kesavananda stand was, it restored that. It exists, let's say that. And then let's say that it is stated that, which we'll talk when we'll take DPSP, that there is harmony between DPSP and fundamental rights. The exact relationship we'll talk when we'll take that DPSP. So, in a way, if you talk in one line, so it restored constitutional supremacy. Finally, let's say it restored constitutional supremacy. Yes. Therefore, the evolution of amendability debate, the evolution of amendability debate or basic structure finally ended with Minerva Mills case. Minerva Mills case, which is considered as phase first in its evolution, as first point within that, as first, the government did not react. The government did not react to Minerva Mills judgment. The government did not react to Minerva Mills judgment. And second, after 1980, time to time, Supreme Court, in some important judgments, has not only reiterated the basic structure doctrine, but also has expanded its scope. Yes. Finally, constitutional supremacy was restored. Which India adopted as against judicial supremacy of US, and parliamentary supremacy of UK. I will tell you separately कि ये क्या है. This. So far it is clear.
So, Kesavananda Bharati case, did it invalidate 51A also? Did it invalidate 51A also?
No. 31A, B, C, they are valid.
A, B, C.
Yes. No, we have not told like. Let's take this. See, in Shankari Prasad case it happened, right? This. The Shankari Prasad case, no, the Shankari Prasad case did not did not invalidate 31A and 31B.
No, sir, Kesavananda.
They have not invalidated 31A, 31B, 31C. They consider them as valid. See, it was 31C which was challenged. Try to understand. Because 31C was added by 24th Amendment Act. In Kesavananda Bharati case, 24th Amendment was challenged. And 24th Amendment added 31C. Yes. So they will take view on 31C. Yes. And 31C was validated by Kesavananda Bharati. No.
And so in 31B, when they say any law kept under Schedule 9 will not be subject to a judicial review, that was also struck out.
Yes, yes.
Any law kept under Schedule 9 will not be subject to judicial review. Was it?
Yes, it was struck. This. Right. 31, 31A, 31B, 31C, they are valid. This 31D was invalidated. This then 30. Let's see. Schedule 9 was not struck. Rather, it was told that whatever you keep in Schedule 9, it would be subject to judicial review. This. In First Amendment Act, what they did is that they told that schedule, whatever the let's say laws you keep in Schedule 9, they would be outside the purview of judicial review.
That also it struck.
So it was struck by Kesavananda Bharati case.
That was struck.
Yes, no, Schedule 9 will be purview of judicial review because judicial review is one such basic structure. Right? Yes, yes.
So जैसे हमने ना 31B में लिखा है कि any law kept under Schedule 9 will not be subject to judicial review.
Try to understand. It is 31B which gives protection to Schedule 9. This. So what they do is that they are not striking. Try to understand. Although we have written here struck, it is not striking, let's say, entirety. Rather, they are saying that 31B can give protection to Schedule 9, but whatever the law you keep under Schedule 9, it will be subject to judicial review.
Like it amended it like after this date it will be under judicial review, but before.
Yes, that was the judgment day. Right. The judgment of Kesavananda Bharati was 24th April 1973. So thereafter, if you keep any law under Schedule 9, so that will be subject to judicial review. All those laws which were kept before that, so judiciary will not review them.
So 31A, 31B, 31C are there.
Yes, they remain valid. The only thing is that they are subject to judicial review. Are you able to understand? देखो साइड बाय साइड और भी सारे डेवलपमेंट होता है जो आप बाद में जब सारा चीज जान जाओ समझोगे आप. साइड बाय साइड ये भी डेवलप होता है जो दूसरे आर्टिकल्स में डेवलप होता है कि रिस्ट्रिक्शन जो होना चाहिए वो रिजनेबल होना चाहिए. ठीक है, जो इस पार्ट का वो डेवलपमेंट नहीं है. तो आप कोई भी लॉ आर्बिट्रेरी नहीं बना सकते हैं. यू कैन नॉट मेक एनी लॉ आर्बिट्रेरी, राइट. वो केस बाय केस जुडिशियल रिव्यू होगा. इवन 39B and C you are giving precedence over 14 and 19. That does not mean कि anything you can bring and take away right to equality and freedom. Still citizens will challenge कि the action of government is arbitrary. Right. But कोर्ट ये देखेगा कि वो आर्बिट्रेरी है कि नहीं, रीजनेबल है कि नहीं. बट सिटीजन्स के पास राइट नहीं होगा वो कोर्ट जाने का. ये और बात है कि कोर्ट एक्सेप्ट करता है कि नहीं. गेटिंग? justiciability is legally lost. Now it is up to discretion of the court. राइट, बट जब जस्टिसिएबल है तो डिस्क्रिप्शन नहीं है, कोर्ट का ड्यूटी है आपके राइट को प्रोटेक्ट करना. दिस डिस्क्रिप्शन इज वन थिंग, ड्यूटी इज अनदर थिंग. कोर्ट इज बाउंड. अगर सिटीजन का फंडामेंटल राइट्स वायलेट होता है, सुप्रीम कोर्ट इज बाउंड टू गिव यू रेमेडी. It does not have discretion. This you should understand. It is bound to give you remedy. Right.
Sir, by playing with good words like constitutional supremacy, basic structure, it is not like Supreme Court emerged as powerful entity than government itself, and the government is what it is a representation of people, so it violates constitution.
Yes. This will debate a bit later. Your point is valid. Right. But we'll debate it a bit later. Like this. When we'll take basic structure separately. Right. इनफैक्ट अभी तो ये कम ही है, जब जुडिशियल एक्टिविज्म की बात होगी, जुडिशियल ओवररीच की बात होगी, तो आपको लगेगा कि इट इज द जुडिशरी व्हिच इज गवर्निंग रादर देन द फर्स्ट टू ऑर्गन्स. So they will bring all these things. But before we come, let's take the clarity.
They can mold constitution by their demand.
देखो, एक पॉइंट में अगर मैं आपका डिबेट खत्म करूं, मतलब कि बाद में मैं आपके डिबेट पर आऊंगा, तो ये है कि देखो उनका कोई अपना एजेंडा नहीं है. राइट. दे डोंट हैव अल्टीरियर मोटिव. राइट. whatever they do for the service of the nation. This. And somewhere the buck should stop. Someone should have a final say. Otherwise, right. जुडिशरी कॉन्स्टिट्यूशन के लिए थ्रेट नहीं है. Right. The first two organs are.
But it is a threat to government.
It is threat to that government which is not constitutional. This. देखो, गवर्नमेंट्स को, सॉरी टू से दैट, उनके अंदर कॉन्स्टिट्यूशनल मोरालिटी नहीं है. फिर से हम लोग अननेसेसरी बात करने लगेंगे. ये सब मतलब जनरल बात होता है सब. तो कॉन्स्टिट्यूशनल मोरालिटी नहीं है इसलिए कि वो पढ़े लिखे नहीं है. आज का नहीं, मैं सेकेंड डेकेड के बाद की स्टोरी है. 2 डेकेड्स के बाद जब गवर्नमेंट में जो लोग भी आ रहे हैं तो वो पढ़े लिखे नहीं है ज़्यादा. दिस. और एक कम पढ़ा लिखा आदमी, आप जो पढ़ लिख के जाओगे तो आपको उसको असिस्ट करना है. इट इज अ मिसमैच. इसीलिए जो सरकार में लोग हैं वो पढ़े लिखे लोग होने चाहिए. आप बाहर के देशों को देख सकते हो ना, लोग जो प्रेसिडेंट होते हैं, जो प्राइम मिनिस्टर होते हैं, अपने आप में ही एक वो लीडर एंटरप्रेन्योर होता है. बस. बट हमारे यहाँ इसका कोई वो नहीं है ना. बस. सो इस बहुत ही एंडलेस, मतलब पूरे पॉलिटी में यही सब डिबेट चलता रहेगा. बस लास्ट में आप समझ जाओगे कि व्हाट आर द थिंग्स. दैट this curiosity will come down gradually. So things will start getting settled. The debate, when we talk. Yes, judiciary should not do that. But if it does not do that, then
I do think it is loss of like it is a negative view in the society for judiciary.
yes, yes.
It is a negative view in society for judiciary.
वो नेगेटिव इसलिए दे आर,
Like people say they are corrupt, higher judiciary corrupt. Their objectivity is
देखो, करप्शन इज ऑमनी प्रेजेंट. हर जगह है वो. तो ये कोई बड़ी चीज नहीं है कि देयर इज करप्शन इन जुडिशरी. इसीलिए चेक्स एंड बैलेंसेस बनाया गया था. There should be checks and balances. कि अगर वो करप्ट है तो दूसरा उसको रोकेगा, अगर वो करप्ट है तो तीसरा उसको रोकेगा, अगर तीनों करप्ट है तो लोग रोकेंगे. वी हैव टू सी इन दिस वे. हम अगर दिस दैट टाइप का अगर डिबेट करते हैं ना तो वो ठीक नहीं है. राइट, आई हैव बीन टेलिंग यू फ्रॉम द डे वन, लेट्स से जो सोसाइटी में जिस तरह से अब डिबेट होता है वो डिबेट ठीक नहीं है. राइट, दिस एंड दैट करके डिबेट. Anyhow, so basically this is how, let's say, it settles evolution and all these things. Thereafter it becomes clear that the constitution can be amended, fundamental rights can be amended except basic structure, and judiciary can review. The three things we can take. One, fundamental rights can be amended including any other parts of the constitution. Second, any that amendment carried out should not obstruct, dilute the basic structure doctrine. And the third, that any amendment carried out is subject to judicial review. This. That 3 lines you can write. So let's write. In summary, the evolution can be summarized as first, fundamental rights can be amended. Fundamental rights can be amended, including any other parts of Constitution. Next, the amendments are subject to Basic Structure Doctrine. The amendments are subject to Basic Structure Doctrine. Next, any amendment carried out is subject to judicial review. Including Schedule 9. So that is how we can write. Let's write about Basic Structure Doctrine. About Basic Structure Doctrine. This. So far it is clear. Once again I will ask, do you have any doubt? Any doubt?
Sir, I have to go through it again.
Yes, you have to go multiple times. Then it will come in your mind. Right. So, but things will gradually come up. Let's say that. What we told that debate starts with law. The term law in Article 13. Whether term law in Article 13 also includes a law made by Constitutional Amendment Act. Now, if it includes, then Constitution cannot be amended, and if it does not include, then Constitution can be amended, especially fundamental rights. So Shankari Prasad case says, Supreme Court in Shankari Prasad, that law made through constitutional amendment does not include under the law of Article 13. Hence, fundamental rights could be amended. The government amended, first amendment was justified. Further down the line, another challenge came, which we say as Golaknath case. In Golaknath case, Supreme Court went the other side. It took a very absolute stand that no, the law includes the law also under law. Means amended law also includes under Article 13 law. Hence, fundamental rights cannot be amended. In fact, they use some terms, the transcendental position, immutable, absolute. So trying to imitate US Constitution basically. So it says that fundamental rights are absolute, they are immutable, you cannot amend them, they are absolute. This. So that absoluteness affected the government role. The government was amending. Then government reacted by 24th, 25th Amendment Act. Then again challenge, Kesavananda Bharati. Here it interpreted that the law under Article 13 does not include law made through amendment, hence you can amend fundamental rights. It says that you can amend fundamental rights, but it says that at the same time you are bound by a basic structure doctrine. What is basic structure? We'll talk this. So you are bound by this. It says that you can amend, but you will be bound. You can eat, but in regulation. This way you should understand. So that is how it says. But it does not define basic structure. Rather, again, it evolves. This, and then let's say that it also struck some of the things, let's say, by bringing also Schedule 9 under purview of judicial review. This. Now, since Parliament was bound by basic structure and framers of the Constitution did not impose any such, let's say, limitation, at that time the executive or legislature, they had understanding that no, Parliament was not bound. So, judiciary cannot impose limitation. And hence they, by 42nd Amendment Act, they rejected basic structure doctrine. Right. And they gave entire DPSP precedence over fundamental rights. Then Minerva Mills case, court restores Kesavananda Bharati judgment. Yes. It says that there is basic structure doctrine. Parliament has limited amending powers. This, so that we will find that, and it, let's say that again restores the supremacy of Constitution. This, and it struck some of the provisions of 42nd Amendment Act. That way, this is how the things have gone. Right. Finally, they got settled. So then comes that what is basic structure doctrine. Right. It is also known as basic feature. We can say that core values, basic, So whether you say basic tenet, whether you say basic intent, whether you say core values, core principles, fundamental values, आप कोई भी नाम दे सकते हो basic structure. Yes. And the framers of the constitution, they court will say that they did not intend that those core values should change. This other values you can change, but those core values should not change, because if core values would change, then you know what will happen. This, so that can result into distortion, that can result into dilution, that can affect constitutional governance. This. So then question, let's say, comes that then let's see what is basic structure, this we have told, but question comes why they did not define it, they have not defined that. Just these are that word they use, but they have not properly defined. The judiciary has not defined. Why it has not defined? There is also logic on that. It says that it cannot be defined. Since constitution is organic, hence basic structure principle should be defined in the light of its own time. That's why time to time they try to say this is basic structure. This is basic structure. This. So then, since then they have given some of those, let's say, basic structure, which let's say we can find any book lists those basic structure. But at one place they have not tried to define it and give an exhaustive list of those basic structure principles. Rather, they time to time they innovate and reiterate this. That we can consider. Why? Because let's say basic structure, in a way, let's say values, basic values cannot be that defined in some terms, otherwise that will itself become a limitation. Right? The values can be well understood rather than codified. This you should know. Like we told you that yesterday or day before yesterday, that US Constitution does not clearly list fundamental rights. This you should know. The way we have listed a set of fundamental rights, US Constitution does not list this. So then it means it has been given power to judiciary to time define those fundamental rights. Even citizens' natural rights are also fundamental rights. This is how it is said. But in our country what we have done is we have tried to codify it. अब codification का एक limitation ये है कि know that कि time to time judiciary has went on saying it is a fundamental right, it is a fundamental right, it is a fundamental right. Right. In Article 21 you will know that one day will tell you this. So that is how, let's say that both aspects you can have. If you codify, you can properly define it, they quantify it, then it can have its own limitation. It is well understood, we can consider some of those major things they have told, which are enough to work as a guiding principle. That we can say. So then the question will come that it is a judicial innovation. So since it is a judicial innovation, so whether framers of the constitution intended this, right? How come they know that the framers of the constitution intended? Right? So this, it is said that whether they intended to impose a limitation on parliament or whether parliament was given unbound power to amend this. So that comes, and it is an extra constitutional development. So can we say that extra constitutional development, extra constitutional means which is not part of constitution. Can an extra constitutional development, that's also by an organ which is not representative of people, right, impose such limitations on the representative of people? That question. So there are criticisms. It's not that there are no criticisms. Plus it is a very thin, let's say that majority, 7-6. 7 in majority, 6 in minority. It was a 13 bench judgment. 13 judge bench judgment. This. So 13 judges, that was highest ever. Kesavananda Bharati Case. The 13 judges and 13 judges, the 7 in majority, 6 in minority. So only by one margin. this. So this question, let's say. So it is quite possible that a larger bench can nullify it. 13, after that you have 15. So larger bench can nullify it. So someday it can be possible. Now, if grievance related to Indian Constitution increases, anyhow, so it can be possible, let's say that, ki larger bench can nullify it. Then what we will do? So this we can consider. So that criticism has been, this is how Parliament should be bound by a judicial innovation called basic structure. This. And recently you know that ki Vice President, right, the Vice President gave his statement ki it is judicial accesses, let's say that. Once it is the legislature who should have the final say, not the judiciary. Yes. So once legislature had made a law, amended the constitution, judiciary should not strike it. This, although being a constitutional position, he should not give this statement. Why? When judiciary passes any judgment, it is the legal duty of the government to implement it. This you should know. If government wants to question it, it is not government, it is legislature, which can question not by speaking, but by a law. This you should understand. So he should have not given this statement, but anyhow forget about this, whether he should give or not. The recent time, let's say, there is this is how the view, basic structure related and criticism to basic structure like this, which judiciary responded. You should know also. The judiciary responded also in informal way. People should not give public statement. They should not speak, right, let's say, publicly about this. Right? Because this is how the buck should stop somewhere. This. So there are, let's say that what you can say, con side or judiciary is criticized. But significance is more important than criticism. Right? If judiciary had not innovated basic structure doctrine, the constitution could have not been saved. Right? It would have been the subject to whims and fancies of the first two organs. And they could have distorted like anything. This, including giving precedence to DPSP over fundamental rights. This. Then constitution will have no meaning. When you have a legal document that you considered as a fundamental law of the land, and that fundamental law of the land does not have sacrosanctity, means sacrosanct nature, let's say that, if it does not have, so how it can promote constitutional governance? How it can promote stability and order in society and rule of law? Because its own provisions are not permanent. They can be changed at will. This. So then it will lose respect also. When constitution lacks that sacrosanct nature, the people will also not have respect to constitution. This. And when people will not have respect to constitution, you cannot impose rule of law. You cannot have a rule of law. Hence, there should be something in constitution which should be given, right, above all, let's say that, above all, let's supreme position that you can consider, which should work as a guide for all the three organs, right. This, why? Because we are still evolving as a democracy, as a federal polity. We are not evolved like UK, and we are not, let's say, evolved like US. This, and that is how, let's say that this, although in US fundamental rights are absolute. You can imagine. यहाँ तो बेसिक स्ट्रक्चर डॉक्ट्रिन का ही सिर्फ लिमिटेशन है. US Congress cannot take away fundamental rights of citizens in any situation. It's absolute. This. We have qualified fundamental rights. They have absolute fundamental rights. तो स्टिल बेसिक स्ट्रक्चर के होने के बाद भी हमारे यहाँ फ्लेक्सिबिलिटी है. वहां तो उन्होंने मना ही कर दिया कि नो, फंडामेंटल राइट्स आर एब्सोल्यूट. हमारे यहाँ तो एब्सोल्यूट नहीं है, इसीलिए फंडामेंटल राइट्स आर डाइल्यूटेड ऑल्सो. ये तो जुडिशरी है जो उन्होंने प्रोटेक्ट करके रखा है. Judiciary works as Krishna of Mahabharata to ensure that the yuddha happens and there is victory of truth. That you should understand. That way, if you see like that, you should see in that way. Right. So the question is, let's say, if those, let's say, right to property. Right to property is not fundamental right. US के constitution में right to property is a fundamental right. Yes. And liberty without property is meaningless. We'll teach you one day. Right. आप लिबर्टी का क्या करोगे जो आपके प्रॉपर्टी का कोई गारंटी नहीं है. कोई भी बुलडोजर चला देगा. राइट. अब वो कैसे समझ में आएगा? तो उसके लिए आपको जॉन लॉक को समझना पड़ेगा, डेमोक्रेसी को समझना पड़ेगा, लिबर्टी क्या है वो समझना पड़ेगा. एंड ही नेवर टॉक लिबर्टी सेपरेट फ्रॉम प्रॉपर्टी. दिस शुड नो दैट. लिबर्टी इज ऑलवेज एक्कम्पनीड विथ प्रॉपर्टी, जिसको बोलते हैं लिबर्टी एंड प्रॉपर्टी. दिस. बट यहां पे क्या हो रहा है? दिस आप समझने की कोशिश करो. कोई ठेला वाला जा रहा है, पुलिस ने डंडा मार के उसका गिरा दिया. राइट. आप कर दो, यूएस में केस कर देगा उसके ऊपर और देना पड़ेगा कंपनसेशन. आप किसी के घर पे बुलडोजर चला दे रहे हो. दिस लोगों को अच्छा लग रहा है, अच्छी बात. So you have to understand this. Right to property in entire Western countries, including in Japan also, you know that it is a fundamental right. Yes, but हम लोगों ने क्या किया? Right to property हटा दिया. Yes. So that is what, let's say, we have to see it. It has criticism, but if we, let's say, we had not innovated basic structure doctrine, we could have failed to have constitutional governance, have respect for the constitution, and, let's say, give certain permanency, stability order in constitution, gives respect to that judiciary where people have still hope when all else fail. This. It is the constitution which still provides that, let's say, guiding light. Be it Manipur incident, be it Nuh incident, be it whatever the incident, on what basis you go to court and why court should intervene. अगर ये sacrosanct नहीं होता तो constitutional remedies भी taken away. Judicial review तो उन्होंने हटा ही लिया था. You should know that. So 42nd Amendment Act, forget about this. 39th Amendment Act, जो हमने mention नहीं किया है. 39th Amendment Act gave special protection to Prime Minister election and Speaker election. That they cannot be court challenged in the court. This. So इस तरीके से तो हर आदमी को protection मिल गया होता फिर. Isn't it? Government by whims and fancies may start giving protection to all those individuals. This, the judicial review you can consider. It could have been narrowed down, judicial independence, and then people will not have faith even in judiciary. That is how it has done more service. In fact, it has saved your constitution from collapse, you can say, or from getting, let's say, disrespected, although people can have some negative views and some criticisms. But even those people who have negative views, when they face injustice, it is the same court and it is the same law which give them justice. That is how you should know this. That is what we have to tell it. So we should not see in that way. Rather, we should see that the framers of the constitution intended to establish constitutional supremacy, and courts have done that only. They have upheld supremacy of constitution. Yes, that is what we have to write. So let's write. Great. Although the basic structure doctrine, has not been defined by the court, but it is understood in terms of basic intent, core values, or basic tenet of the constitution, which framers of the constitution intended to promote and preserve. The court has not defined also due to the fact that Constitution is an organic document. And it should be defined in the light of its own time. However, time to time in various judgments, the Supreme Court has defined principles of basic structure, of which some of them are as follows. First, supremacy of constitution, rule of law, next, independence of judiciary, next, judicial review, federal polity, parliamentary system, dignity of life, social justice and welfare, balance between fundamental rights and DPSP. Next, limited amending powers of Parliament. limited amending powers of Parliament, secularism, etc. However, still there are criticisms. There are criticisms that first, it is an extra constitutional development. It is an extra constitutional development. Next, it is a judicial innovation. It is a judicial innovation. Next, whether framers of constitution, intended to impose limitations on parliament, on its amendability power, Next, it has not been properly defined. The list is not exhaustive. Next, the list is not exhaustive. Next, it was a majority decision by a margin of one judge. Next, judiciary is not a representative body. Then, can it impose limitations? On the first two organs, which are representative of people? In bracket, can judiciary come on the way of popular sovereignty? See, popular sovereignty means will of people. Right? Will of people, we say that. This. So these are, let's say that, criticisms to basic structure, why it is this, that, etc. Let's write. Nevertheless, right, basic structure doctrine, right, is justified on following grounds, or there should be something which even the first two organs, should be bound to follow. The first point, let's read. India went for adopting constitutional supremacy. Which cannot be upheld cannot be upheld without basic structure. Without basic structure. Next, the first two organs can have their whims and fancies if they have overwhelming majority. If they have overwhelming majority by one party. In bracket, a strong executive has posed threat to constitutional governance. A strong executive has posed threat to constitutional governance. Next, the working of constitution since independence shows that on numerous occasions, constitutional governance was compromised. And it is the judiciary which came to rescue Constitution through its landmark judgments, including the most recent one of electoral bond judgment. That change paragraph. That is the Lakshman Rekha. The inviolate line should not only apply to judiciary but also to the first two organs. Unless Constitution has its sacrosanct nature, especially some core values, both those who govern and those who are governed will not have respect for the Constitution. And that will seriously threaten constitutional governance. Change paragraph. In fact, in Indian case, even by basic structure doctrine, Parliament has flexibility in amending Constitution, including fundamental rights fundamental rights like 44th Amendment Act, 44th Amendment Act took away right to property, right to property. But in case of US, fundamental rights are absolute. Absolute. The US Congress does not have power. The US Congress does not have power to take away fundamental rights. Take away fundamental rights. Right. In a way, it is absolute. In a way, it is absolute restriction on the powers of the Congress. Congress. This. Therefore, the basic structure doctrine should be seen from broad perspective of first the constitutional positions in the Western countries, especially US and UK. US and UK. Second, the intent of the framers of the Constitution. Intent of the framers of the Constitution. Next, the evolutionary nature of Indian democracy. Evolutionary nature of Indian democracy, including transitional nature of society. That judiciary cannot remain a mute spectator, rather it has a duty cast upon as the guardian of the Constitution, and protector of fundamental rights to protect and promote constitutional governance. That is what this. So when we'll take judiciary part, so further understanding will come like this. So we see in that way when we talk. Right. Still, let's say some basic thing you can add. So this 39th Amendment Act, it was done to protect elections of Prime Minister and Speaker. This. So they were kept outside the purview of judiciary. Judiciary cannot review their elections. Judiciary cannot review. This came to be known as, another case it is known as Indra Nehru case. Or which we say as Raj Narayan case popularly, which will talk, it will come several times. The Raj Narayan case, and the court struck this, struck 39th Amendment. Yes. Then one thing, let's say, basically basic structure was first invoked in 1953. Just for facts, right? पहली बार basic structure was not used in 73. Rather, already let's say that कि in a dissent means in a minority view, Justice Mudholkar had talked about basic structure. This. Right?
They use the term basic structure. They used the
Yes,
term
in his statement he uses the term basic structure. Although it is not clear, let's say that, but something we should be bound judgment when we give her the amendment, let's say that, when case was dealt.
What was the case? What was the case?
It was, I guess, ki Sajjan Singh related to liberty related case it was. This Sajjan Singh hai शायद Sajjan
This was after
Shankari
Shankari
Prasad.
case. So this was the second time they told that
Yes. If it is.
you can amend the fundamental rights, but not everyone.
Yes, yes. So this, so by that way we take, let's finish basic structure. Any question, any doubt?
Is it a purely Indian innovation or do we find some precedent?
Right. नहीं ऐसा कुछ नहीं है, शायद पाकिस्तान में भी है इसका थोड़ा बहुत इनोवेशन. Right. Yes. Yes. So means there are, let's say, practices in other countries, although very limited. This very limited. This बेसिकली देखो इतने ही डिबेट से कई सारे और डिबेट होता है जो अलग अलग टॉपिक्स में वी विल रेफर इट दिस अलग मीन्स सेपरेट टॉपिक्स व्हेन विल टेक डीपीएसपी देयर विल टॉक अगेन व्हेन विल टेक जुडिशरी सो विल टॉक अबाउट जुडिशियल रिव्यू हाउ जुडिशियल रिव्यू हैज इवॉल्व्ड तो द फर्स्ट फेज ऑफ जुडिशियल रिव्यू यू सी दिस कि हाउ इट वाज reduced, you can say that there will talk about this judicial review related. So it will be, let's say, talked in different fashion here and there. That will further improve your understanding. This. So, like say कि basic structure, it improves the scope of judicial review. This, but that you will understand when we'll take. Let's talk about constitutional supremacy. Constitutional supremacy. By the way, how come we know there is constitutional supremacy? Which provisions of the Constitution, let's say that, ensure that Constitution is supreme? Right. So that is how, let's say, So constitutional supremacy will come by Article 13 plus entire part 3 plus Article 32 to 26. This you can say. So that way we can say. Then you can find that judgments. Some judgments, let's say, they have given clarity on constitutional supremacy, like basic structure. Then let's called limited amending power. Parliament. Then judiciary as guardian of the constitution, right, protector of fundamental right, final interpreter. This, these things make, let's, these things give supremacy to constitution. Yes.
Written constitution.
Yes, that can also be written and rigid constitution. Written and rigid constitution, right? What does it mean when we say constitutional supremacy? Right. We have a state. The state has three organs: legislature, executive, constitution. All are bound by this. All are bound by constitution. This, how we understand this? Why, how all are bound by this? So basically, let's say that there are two other, examples. So if you take US, it has judicial supremacy. If you take UK, it has parliamentary supremacy. It's, India has balanced it midway. Constitutional supremacy. अब ये क्या है? You may be familiar with some of the things, isn't it? Let me tell that how it is. इसका मतलब क्या है? ये क्यों बात कर रहे हैं हम? This. So let's take UK. So the way society evolved, in UK, you know that people played big role. No? People, this. So when people played big role, so that is how people had faith in legislature. Because legislature was representing will of the people. It is democratic. This, since this is how the society evolved, since it was never a colonial power, rather it colonized instead of being a colonial power. But people there, let's say, democracy, the fight between democracy and monarchy, ultimately democracy wins. So when democracy wins, so that representativeness will be going through parliament. This the people faith, you can say, like one day I told you that ki speaker and the king, let's say that ki raided parliament, so speaker did not tell where the other MPs are. Right? He protected them. So this you can say that the people had faith in this. Therefore, let's say that ki UK Parliament is absolutely sovereign. Right? Means it is not bound by any law. Right? It means it has absolute power to make any law. It has absolute power to make any law. Right? Now, it does not have written constitution. It does not have written constitution. तो when it does not have written constitution, यहाँ पे जो judiciary है, judiciary lacks judicial review of legislative action. The judiciary does not have power to review the law made by the legislature. Judiciary does not have power to strike a law made by UK Parliament. This you should know that. Because there is no written, there is no basis. On what basis you will strike a law? This. So on what basis you will strike a law? That is not present in, you can say that ki UK. Therefore, this is how it is said that ki UK Parliament can make any law, except one thing. Making men women, women men. ये किसी का quote है, right? Right. So that is what we'll find. So the question is that it is absoluteness. तो लोगों का फेथ है और पार्लियामेंट ने उस फेथ को मेंटेन किया है. Even if UK Parliament has absolute power, but it has not threatened rule of law. This. Because rule of law उन्हीं के यहाँ आता है. Rule of law, idea of rule of law, concept of rule of law came on their land. Bill of Rights came on them. Democracy came on them. So all those constitutional system and democratic system, democracy and constitutional developments first happen on UK land in modern times. This is to know that. So that is how, let's say, they have parliamentary supremacy. Can we adopt this parliamentary supremacy? That is how, let's say, that Parliament wanted to become, right, before Kesavananda Bharati case. Right. It was trying to imitate something, let's say that. It was, let's say that, absolutely sovereign and it could make any law. This. But we have not adopted that system. We have a written constitution. We have given fundamental rights. We have blend of also US practice. Right. Therefore, let's say that when you have absolute sovereignty, there is no limitation on parliament to make law. This. The UK does not have this. Now, let's take US. The US has a different history. Right? US was a colony of UK. Yes. So when it was a colony of UK, तो you know that कि it faced all those exploitation जो भी होता है. Right? Therefore, when they got independence, so what they did is that कि they right, they wanted to some completely undo this exploitative system. Right. So to do let's say undo that exploitative system, what they did is that they adopted a written constitution. And written constitution is most rigid constitution that then they went for separation of powers. That's also complete separation of power. They wanted that there should be complete separation of power so that no organ can have, let's say, that absolute power and can become exploitative. This. So when they have separation of power, let's say that, and then they have this, and then they gave citizens absolute fundamental rights. Absolute fundamental rights. Why they did it? They wanted to impose limitations not only on executive but also on legislature. Right. How? They also adopted due process. This, which will talk you later कि due process क्या है. Right. So by this, what they are saying, they are trying to impose limitation on, means only threat is not from executive, threat is also from legislature, because they had a different history. Hence they wanted to impose limitation on legislature also. Right. And therefore they went for complete separation of power. So when they have complete separation of powers, so what happened that separation of power goes in favor of judiciary. Separation of powers goes in favor of judiciary. How? The US Constitution is not a detailed constitution. Since it is not a detailed constitution, so many things have been left to judiciary to define. Right? Many things have been left to judiciary to define which aspect is considered implied powers. राइट, इसको बोलते हैं इम्प्लाइड पावर्स. तो एक कॉन्स्टिट्यूशनल एक्सपर्ट था, उसने ये बोला कि यूएस का कॉन्स्टिट्यूशन क्या है ये जुडिशरी बताती है. राइट, व्हाट इज द कॉन्स्टिट्यूशन ऑफ यूएस इज टोल्ड बाय यूएस जुडिशरी. दिस गेटिंग. देखो, कॉन्स्टिट्यूशन हैज नॉट गिवन डिटेल. लेट्स से कि इट डज नॉट हैव डिटेल लिस्टिंग ऑफ फंडामेंटल राइट्स एज आई टोल्ड. So what are fundamental rights? Would be decided by judiciary. Getting point?
Through basic structure, isn't our judiciary also trying to do that?
Yes, that point will come. Right, that point will come. But we are trying to make you understand what is constitutional supremacy. Why we have supremacy, why we have avoided this. Right, this. So, yes, it is trying to bring, let's say, some of the things like this. So, What are fundamental rights will be defined by judiciary, and fundamental rights are absolute, but they can be limited by judiciary. Try to understand. Fundamental rights are absolute, but judiciary can suspend fundamental rights. The power to suspend fundamental rights lies with judiciary, not with first two organs. This power has been given to judiciary. This plus due process is a very subjective thing. The government action, including legislature, should be subject to due process, means it should be reasonable and just, which will tell you about Article 21. Right? All these things have shifted power towards judiciary, you know that. This so much so that in 1803, you know that this is how it comes, judicial activism, Justice Marshall case, and first time US Supreme Court struck a law made by US Congress. That is beginning of judicial activism. One day we'll talk that. Anyhow, so basically what has happened, it has shifted powers, let's say that, towards, that is how you were trying to say. But we do not want judicial supremacy because it is not good. You know that. It shifts power towards judiciary. So we have learned it, framers of the constitution were aware about this, hence they did not want to give undue powers to judiciary. This. And then at the same time they were also aware about UK system where parliament had absolute power. Therefore we went to adopt supremacy of constitution, that all the three organs should be bound by constitution, the provisions of the constitution. That we say as constitutional supremacy, that even judiciary is also bound by that constitution. Right. Now you should know what judiciary has tried. So basically by judicial actions, judiciary has also tried to acquire more and more powers. This you should know that. And it has become more powerful than what framers of the constitution gave power within constitution. The power has shifted also towards judiciary. But that's matter to talk later on somewhere else when we'll talk judiciary, judicial activism, etc. There we'll talk. Here we'll not talk about this. Right. But we have tried to follow constitutional supremacy. This is should know that. And this is how they have done by bringing basic structure doctrine, right, and nullifying the actions of legislature again and again through, let's say, cases will find that. They have tried to uphold that constitutional supremacy. This is what we can say. So that way you can see this. Right.
So can we add that one also, checks and balances?
Yes, that's why we also did not go for complete separation of powers. It results into rigidity. We went for, let's say, delicate separation of powers with checks and balances. This, which we'll talk when we'll take separation of powers. Are you able to understand? Basically, such debates are nothing but state, three organs, which organs should exercise how much power, and ultimate aspect is how we can protect the rights of people, liberty of people. This. The few lines I will tell, let's summarize on this. The two major systems led by UK and US, UK and US, so two extreme practices due to their own historical past, that first UK evolved to give absolute power to Parliament, absolute power to Parliament. Next, US, on the other hand, evolved to ensure that no organ enjoyed absolute power. However, that resulted into shifting of powers, towards judiciary. And that's why it has judicial supremacy. Supremacy. However, the framers of the Constitution avoided the two extremes. The framers of the Constitution avoided the two extremes by adopting constitutional supremacy. That in India, no organ is supreme. Rather, all are bound by, no organ is supreme, rather, all are bound by Constitution. Judiciary by basic structure doctrine. Has tried to uphold constitutional supremacy. That is what we can say. Right? Criticisms will not talk, that, not needed, because later on we'll talk when we'll take judiciary. So this is one part of the debate, a bit technical part of the debate of fundamental rights. So before teaching fundamental rights, we have taught you about Article 13, Article 12, what is a state, what is law, amendments of the Constitution. So that yesterday we talked flexibility, rigidity. Today we have talked about how basic structure has evolved, basic structure doctrine, and after that, let's say, what happens. After that, we have not given focus, because since we will teach you here and there, at the end of the day, you will be yourself able to bring together. To post Kesavananda Bharati, we do not give more. Rather, yes, they have tried to re-strengthen by, let's say, time to time, defining this and that. This. Why it has been done? So that is about constitutional supremacy. This. And reverence to Constitution. We'll talk some other things also one day, because first you deal with constitutional supremacy, basic structure. So then we will talk one day about constitutional morality and constitutionalism. Then अभी बात करेंगे तो आप थोड़ा कंफ्यूज होने लगेंगे. But love to Constitution, how it will come? Do we love our Constitution? Do we respect our Constitution? तो जब आप कॉन्स्टिट्यूशन को लव करोगे, रिस्पेक्ट करोगे, जिसको बोलते हैं रिवियरेंस टू कॉन्स्टिट्यूशन, you will not be harmful to other citizens. Right? You will not destroy our own properties. This, जो हमारे यहाँ प्रोटेस्ट फ्रीडम अपना दिखाते हैं और प्रॉपर्टी लोगों का तोड़ते हैं. This, तो प्रोटेस्ट होगा तो फिर आप प्रॉपर्टी को बर्न नहीं करोगे. राइट? पुलिस लाठीचार्ज नहीं करेगी. रिवियरेंस टू कॉन्स्टिट्यूशन ये होता है. दिस शुड नो दैट शुड बी इन योर हार्ट. दैट इज कॉल्ड, लेट्स से दैट की दिस इज व्हाट दे आर ट्राइंग टू से. दिस सो this constitutional supremacy, basic structure doctrine, it has tried to protect Constitution, give permanency that we told yesterday. It is rigidity and flexibility. The Constitution cannot be completely a flexible document that you can keep changing it as it will give rise to ad hocism. This. So that way, that light we should see, but yes, it does have some weakness, criticism that for negative you should